Welcome to Earth IAS. Dear students, I hope you are preparing very well for upcoming prelims 2025. And in this lecture, we are going to discuss previous year question paper of polity section of year 2020. Before starting this lecture, I would like to tell you that if you have any kinds of doubts, queries, you can comment in the comment box or you can mail us. This is our official mail ID earthias.enquiry@gmail.com. I will personally answer your queries or doubts as soon as possible. Right now, let's start. So, as I told you, we would discuss the PYQs of polity section of 2020. So, first question is about, it says, in India, separation of judiciary from executive is enjoined by. If you have read polity, right, you are well prepared, it would take few seconds. Why? Because it talks about separation of judiciary from executive. Right? Indian Constitution has adopted separation of power between legislature, executive, and judiciary. But which of the following talks about? For example, preamble of the Constitution of India. No, nowhere preamble talks about separation of judiciary from executive. Second, directive principle of state policy. Obviously, right, under Article 50. Under Article 50, there is provision for separation of judiciary from the executive. So, B is the right answer. 7th schedule you would be knowing. It talks about division of power among center and state. 3 list, union list, state list, concurrent list. Conventional practice? No. So, B is the right answer of this question. Means directive principle of state policy under Article 50 talks about separation of judiciary from the executive. Here is the explanation. You can pause the video and you can read. Next. One common agreement between Gandhism and Marxism. Right? So, common agreement. If you are a student of, or if you have political science and international relation as your optional paper, you can easily answer this question. Or even by applying your common sense. Or if you have read about Gandhi and Marx, right, you can easily answer this question. So, what is common between Gandhism and Marxism? Common agreement. First says, final goal of a stateless society. Obviously, both Gandhism, Marxism did not favor any kind of state. Right, both. Means Marxism and Gandhism both supports stateless society. That is the common or similarity between Gandhism and Marxism. Otherwise, you do knowing Marxism is violent form or supports violence, but Gandhism supports peace, truth, non-violence. Class struggle, though Marxism talks about class struggle, but Gandhism not. Right? Abolition of private property. Again, Marx supports abolition of private property, but Gandhism never talks about complete abolition of private property. It talks about that though you should have private property, but it should be in limited form. Simple. So this is also not correct. Economic determination, not correct. So A is the right answer. Means the common agreement between Gandhism and Marxism is what? Stateless society. Final goal of a stateless society. Here is the explanation. You can pause the video and you can read. Next, which part of the Constitution declares ideal of a welfare state? Simple. So, directive principle of state policy, fundamental rights, preamble, 7th schedule. If you have read directive principle of state policy, then you would be knowing under Article 38. Under Article 38 says that the state shall endeavor to ensure a welfare state. Simple, right? So A is the right answer. No need to go for fundamental rights. Listen, though fundamental rights try to ensure liberty, equality, or equality, and other kind of, or try to remove other kind of injustice. in society. For example, discrimination based on caste, untouchability. But these are one of the element of welfare state. It does not directly try to ensure welfare state. Preamble, though again preamble talks about justice, social, economic, political, right? But also does not directly talks about welfare state. Seventh schedule, obviously you would be knowing that talks about three list, means division of power between center and state. Three list, union list, state list, concurrent list. So A is the right answer, right? Means the ideal of welfare state is given or part of directive principle of state policy. Under which article? Under article 38. Here is the explanation. You can pause the video and you can read. Right? Already I told you, as per article 38, it is the duty of state, right, strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, political shall inform all the institutions of the national life. Simple. Next, other than fundamental rights, which of the following parts of the constitution reflect or reflects principle and provisions of the Universal Declaration of Human Rights 1948. So you do know that this declaration, Universal Declaration of Human Rights, talks about certain kinds of human rights, and some of them has been included in fundamental rights, some of them has been included in the preamble, right, and even some of the has been included in directive principles and fundamental duties also, right. So it says first preamble already, because preamble talks about justice, social, economic, political. Directive principle of state policy also talks about, for example, it try to ensure welfare state. Again, certain kind of rights, for example, equal pay for equal work, right to work. All these are nothing but comes under directive principle of state policy, and also part of human Universal Declaration of Human Rights. Also, preamble talks about that. And fundamental duties. Fundamental duties, for example, it promotes or it talks about promotion of fraternity, common brotherhood, international peace, scientific temper. Right? So, all these three are correct. Correct answer. Option A says 1 and 2, no. B says 2. C says 1 and 3, no. D says 1, 2 and 3. So D is the right answer. Means preamble, directive principle of state policy, and fundamental duties. All these three talks about the principle and provisions under Universal Declaration of Human Rights 1948. Here is the explanation. You can watch, you can pause the video and you can read. Next, which one of the following categories of fundamental rights incorporate protection against untouchability as a form of discrimination? Obviously, right. So, protection against untouchability is part under which of the categories of fundamental rights? Right. You do know from article 14 to 32. There are 6 categories of fundamental. Listen, not 6 fundamental rights. 6 categories of fundamental rights. So, right or protection against untouchability comes under which category? First, right against exploitation? No. Right to freedom? No. It comes under article 19. Article 19. Right to constitutional remedies comes under article 32. But right to equality, article 14 to 18. Right? And you do, if you know or if you have read, then you would be knowing protection against untouchability comes under article 17. So 17 comes under or comes between 14 to 18, and it is what? Nothing but right to equality. So protection or fundamental rights that incorporate protection against untouchability is right to equality. Simply by applying your common sense, guessing sense. Even if you have forgotten that particular article, you can correct this answer. Simple. Already I have explained. Next, the preamble of the Constitution of India is, right? Be very specific. Especially, always I suggest you that whenever you read single response question, you read all the options first, then answer the question, and read all the options very carefully, because when you will read the options, you will find each of them are very close. For example, first says part of the Constitution but has no legal effect. In hasty manner, you will take this, but stop. Right? It says part of the Constitution but has no legal effect. Half of the statement is correct, but it says completely has no legal effect. You should stop here. Next, not a part of the Constitution and has no legal effect either. Just cut it. Because you would be knowing that in Keswanand Bharti case, the Supreme Court upheld that preamble is part of Indian Constitution. Again, in LIC of India case, it repeated further. Next says a part of the Constitution and has same legal effect as any other part. No. Half of the statement is correct, but half of the statement is not correct. Next, a part of the Constitution but has no legal effect. See, option A and D till here are same, but rest it says has no legal effect independently of other parts. So this would be the right answer. Why? Because you would be knowing that Supreme Court takes cognizance or reference of the preamble while interpreting the Constitution. So you can't say that it does not have any legal effect, right? But independently, it has no legal effect, right? So D is the right answer. Means preamble is part of the Constitution but has no legal effect independently of other parts. Here is the explanation. You can read. Next, seventh question. It says, consider the following statement. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Listen, be very careful. The Constitution of India defines its basic structure. Absolutely wrong. Why? Because nowhere the Constitution of India defines basic structure. This doctrine of basic structure was propounded by the Supreme Court in Keswanand Bharti case. It was not incorporated in the Indian Constitution originally. So this statement is incorrect. Next, the Constitution of India provides for judicial review. Obviously, under Article 13, 32, 226, 142, the judiciary has power, right, of judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Obviously, you can go with this option. So, correct answer. A says 1 only, no. B says 2 only. So, B is the right answer. No need to go for C or D. Don't waste your time. So, B is the right answer. Only statement 2 is correct. Next, it says, in the context of India, which one of the following is characteristic appropriate for bureaucracy? So, in future, when you will qualify this exam, you will be part of bureaucracy. And what is the characteristic of bureaucracy? Just read. An agency for widening the scope of parliamentary democracy. No, this is not the characteristic of bureaucracy. Next, an agency for strengthening the structure of federalism. No, also not correct. An agency for facilitating political stability and economic growth. Though they contribute, but this is not the main characteristic or appropriate characteristic of bureaucracy. Though they are part of economic growth, for example, plans, policies are also framed by bureaucrats. But generally, this is not the appropriate answer. Last, an agency for the implementation of public policy. Obviously, when you will become bureaucrat, you will implement the public policies, government schemes, government plans. right? So D is the right answer of this question, right? Characteristic of bureaucracy is means implementation of public policy. Simple. Next, with reference to funds under members of parliament local area development scheme, right? In short, it is known as MP-LADS, member of parliament local area development scheme, right? So basically you can see that this question is from governance topic, right? So it says which of the following statements are correct. First says MP-LADS funds must be used to create durable sets like physical infrastructure for health and education. Very common statement, correct, right? Next, a specified portion of each MP fund must benefit SC or ST population. Obviously, this is also correct, right? A specific portion of MP-led schemes fund should be utilized for SC or ST's population, right? Next says MP-led fund are sanctioned on yearly basis. Obviously, annual basis it is sanctioned. And comment in the comment box how much amount is sanctioned by the government for this particular scheme on annual basis or every year. Comment in the comment box. And the used funds cannot be carried forward for the to the next year. No. Listen, if any funds remain in a particular year, then that remaining fund can be carried forward. Listen, for example, the government, just an example, allocates 5 crore for year 2025 and 2026, and out of 5 crore, for example, 1 crore 1 crore left, right? Then this 1 crore can be carried forward for next year 2026 and 27, right? Plus the new amount, whatever, for example, next year 5 crore, then total amount would be 6 crore. So this statement is wrong. Means the unused fund can be carried, but the statement says it cannot be carried forward for the next year. It can be carried forward for the next year. Next, the district authority must inspect at least 10% of all work under implementation every year. Yes, this statement is correct, right? So you can clearly see statement 1, 2 and 4 are correct. Correct answer: A says 1 and 2, no. B says 3 and 4, no. C says 1, 2 and 3, no. D says 1, 2 and 4, yes. So D is the right answer. Statement 1, 2 and 4 are correct. Moving towards the next question. Here's the explanation. You can pause the video and you can read. Next, in India, legal service authorities provide free legal services. Obviously, it is the duty of the state to provide free legal aid to the poor and vulnerable section of the society who cannot afford legal services, right? To which of the following type of citizens? Not each and every type of citizen can have free legal aid. Only who are poor or vulnerable section, right? So first A says person with an annual income of less than 1 lakh rupees, right? Obviously, listen, though this criteria is or this criteria, income criteria, differ from state to state, but generally most of the state has fixed the limit that if any person's income is less than 1 lakh per annum, then he can get free legal services, right? Next, transgender with an annual income of less than 2 lakh rupees. Obviously, this is also correct, right? And again, I would like to tell you that it also varies from state to state, but most of the state has same income limit, right? For general common citizens, it is 1 lakh. It should be, means his or her income should be less than 1 lakh rupees per annum. For transgender, it should be less than 2 lakh rupees per annum, right? Next, member of other backward classes, OBCs, with an annual income of less than 3 lakh rupees. No, there is no such provision. There is no separate category for OBCs in case of free legal services, right? Simply this income criteria should be followed. Next, all senior citizens. No, listen, again, it is very general statement that all senior citizens, even senior citizens could be rich or poor, So only a specific category of senior citizens are allowed for free legal services. So only statement 1 and 2 are correct. You can say statement 1 says 1 and 2. Obviously, A is the right answer. No need to go for B, C or D. A is the right answer. Only statement 1 and 2 are correct. Here is the explanation. You can pause the video and you can read. Next, it is very simple question, right? Even if you have read NCERT, you can easily answer this question. It says parliamentary system of government in which is one in which, right? So simply ask about parliamentary system of government. It says all political parties in the parliament are represented in the government. No, right? Only majority party is represented in the government. That majority party may forms the government. And second highest party, or you can say party with at least 10% of total number of seats of Lok Sabha represents as opposition, right? So this is wrong. Second says, option B says the government is responsible to the parliament and can be removed by it, right? So obviously, what is the main characteristic of parliamentary system of government? It is accountable, or it ensures accountable form of government. The government is, or you can say council of minister is directly responsible to the lower house, that is Lok Sabha. So it is responsible to the parliament in general, and in particular responsible to the Lok Sabha, and can be removed by it. Obviously this is the right answer. Means, next, read this statement: the government is elected by the people and can be removed by them. Half of the statement is correct, but half of the statement is not correct. Why? Because people cannot remove them. Why? Right? Only parliament can remove them by passing no confidence motion. No confidence motion. Right? People cannot remove them. Though people have chance in the next election to change the government, right? To elect a new government, but people cannot remove the government, because India have, for example, India has indirect democracy, not direct democracy. We don't have right to recall. We only elect the government. We cannot remove them. But parliament can remove them by passing no confidence motion. So option B is the right answer, not C. Right? And D says the government is chosen by the parliament but cannot be removed by it before the completion of a fixed term. No. Right? Meaningless statement. So B is the right answer of this question. Parliamentary system of government means the government is responsible to the parliament and can be removed by it by passing no confidence motion. Here is the explanation. You can pause the video and you can read. Next, again very simple question, right? Simply, a constitutional government by definition is, right, government by legislature? No. Popular government? No. Multi-party government? No. Limited government? Obviously. Where there is constitutional government, there is limited government. Means even the government is not allowed to take arbitrary action. It will always act within the ambit of or under the provision of the constitution. It simply means constitutional government means limited government. Here is the explanation. You can read. Next, 13th number question. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of legislature of that state. If you simply read the statement, you will find that it is correct. But stop. It says, according to the Constitution of India, a person who is eligible to vote can be made a minister. Right? What is the eligible or age criteria to become a voter? It is 18 years. Right? And made a minister in a state. In a state. So to become a minister, right? Even it is allowed in the Indian Constitution that even if a person is not MLA or MP, right, he can be a minister at in the state legislative assembly or in the parliament, provided he or she, right, should be elected within 6 months. But here, in case of legislative assembly or parliament, the minimum age criteria is 25 years, and minimum age criteria for or to become a voter is 18 years. Here the conflict arises, and that's why this statement is wrong. Because for example, any voter who is 18 years or above, for example, just say 22 or 20, 22 or 24, right, but that voter is not 25 years or above, then that person could not become a minister in the state legislative assembly, right? Here is the contradiction, right? So this statement is wrong. Next, according to the Representation of People Act 1951, a person convicted of a criminal offense and sentenced to imprisonment of for 5 years is permanently disqualified from contesting an election even after his release from prison. Listen, this statement is again wrong, because you do know under Representation of People Act 1951, if a person is convicted of imprisonment of in case of criminal case, right, or criminal offense, and the imprisonment of is 2 years or more than 2 years, then that person is disqualified, right? But not permanently disqualified. This statement says permanently disqualified. No, right? That person is disqualified for 6 years, right, from the date of release. Not permanently. Permanently means his life has been ruined. His political career is spoiled. No. So that person after release cannot contest election for 6 years. For 6 years. So both statements are incorrect. It says A says one only, no. B says two only, no. C says both, no. D says neither one nor two. So D is the right answer of this question. Both statements are incorrect. If you want to read, here is the explanation. Already I have explained statement 1 that under Article 164, a person who is not a member of a state legislature can be appointed as a minister provided that they get elected to the legislature within 6 months of their appointment. Eligibility for vote in India is at least 18 years, as I told you, but though additional qualifications like being at least 25 years for legislative assembly may apply for becoming a member of the legislature. So here is contradiction, right? Next statement, as I told you, that if a person, right, under article or section 8 of Representation of People Act 1951 specifies disqualification for contesting election due to criminal conviction for certain offences, a person sentenced to imprisonment of or for 2 years or more, 2 years or more, as I told you, is disqualified from contesting election for a period of for the period imprisonment and an additional 6 years, not permanently, right, from the date of means after release. Simple. So in the conclusion, you already have told you that both statements are incorrect. Next, Rajya Sabha has equal powers with Lok Sabha in, right? You do know in case of money bill, Lok Sabha has overriding powers. In case of creating all India services, Rajya Sabha has more power than Lok Sabha. But there are certain bills or certain conditions or matters where Lok Sabha and Rajya Sabha are equal. So where it is, first says option A says the matter of creating a new all India services. No, here Rajya Sabha has more power, right? Amending the constitution, right? So here both Lok Sabha is equal to Rajya Sabha. Means a constitutional amendment bill can be introduced in either in Lok Sabha or Rajya Sabha. Both have equal powers. Right? Next is removal of the government. No. This is making cut motions. No. So B is the right answer of this question. Here is the explanation. You can pause the video and you can read. Next, with reference to the provisions contained in Part 4 DPSP of the Constitution of India, which of the following statement is or are correct? Part 4, what is it? As I told you, it is DPSPs, Directive Principle of State Policy. It says they shall be enforceable by courts. No, DPSPs, fundamental duties, preamble, they are non-justiciable in nature. Means they are or they shall be, they cannot be, simply you should know, they cannot be enforceable in the court of law. So this statement is incorrect. Second says they shall not be enforceable by any court. Obviously, I told you the same. Next, the principle laid down in this part are to influence the making of laws by the state. Obviously, that's why its name is what? Directive principle. So this DPSP acts like a guiding principle, directive principle, while making any laws, plans, policy, schemes by the state. So this is also correct. So statement 2 and 3 are correct. Correct answer. A says 1 only, no. B says 2 only, no. C says 1 and 3, no. D says 2 and 3. So D is the right answer of this question. Here is the explanation. You can pause the video and you can read. Next, consider the following statements. It says the President of India can summon a session of the Parliament at such place as he or she thinks. Correct. Right. You do know there are 3 sessions: budget, monsoon, winter session, and it is summoned by the President of India, and he can call that session at any place he or she thinks, wherever. Right. So this statement is correct. Next, the Constitution of India provides for 3 sessions. Obviously, I told you: budget, monsoon, winter of the Parliament in a year. Right. But it is not mandatory to conduct all the 3 sessions. Right. So it is incorrect. It is mandatory. It is mandatory to conduct all the 3 sessions. One condition is there: the gap between the 2 sessions should not be more than 6 months. So this is incorrect. Last, there is no minimum number of days that the Parliament is required to meet in a year. Obviously, this is not fixed. Right? Means no minimum number of days is fixed for the meeting of Parliament in a year. So you can clearly say statement 1 and 3 are correct. 2 is incorrect. Right? So correct answer: A says 1 only, no. B says 2 only, no. C says 1 and 3. Obviously, C is the right answer. No need to go for D. So statement 1 and 3 are correct. Option C is the right answer. Here is the explanation. If you can pause and you can read. Last question. It says, along with budget, the finance minister also places other documents before the Parliament, which includes the macroeconomic framework statement. You do know that along with budget, different types of or other documents are also presented. Right, and one of them is what? Macroeconomic framework statement. The aforesaid document is presented because this is mandated by. Right. So, which of the following mandates to present this macroeconomic framework statement? Right. First, long-standing parliamentary convention. No. Article 112 and 110, clause 1 of the Constitution of India. No. 112, it is nothing but budget. But the Constitution does not use the term budget. It uses the term annual financial statement. So under article 112 it is annual financial statement, that is generally known as budget. 110 clause 1 it is related with money bill, and 6 sub clauses are there from A to F, which talks about the criteria of money bill, right, or conditions for money bill. It is also not correct. Next, article 113 of the constitution, no. D, provisions of the fiscal responsibility and budget management act 2003. In simple, it is known as FRBM act 2003. So under this act, this statement is presented in the parliament. So D is the right answer. Right? Here is the explanation. You can pause the video and you can read. So that's all for now. In this video, we have discussed PYQs of 2020 of polity section. If you want to download the PDF, the link is given in the description box. You can go and download the PDF of these questions along with explanation. Till then, keep revising, keep practicing. Each and every second is important. Thank you for watching.